Hello, everyone. Thank you for a wonderful response you have given to me for the initiative I have taken. Very supportive, and that really encouraging me to proceed further, and do more and more videos about the subjects and the course. So today I would like to start with the executive and the company law subject first chapter, that is Introduction to Company Law. See, whenever you really starting any subject, if there are any bifurcations, something like this part one 60 marks and part two 40 marks, you accordingly you really have to bifurcate the marks and bifurcate the chapters, and then you just focus more on the part first. See here, there are six chapters for the 40 marks and there are 11 chapters for the 60 marks. So if we actually do have expertise and explicit knowledge about these four chapters, we end up scoring 40 marks. There might be, if we just score 20-25 marks in the part one, we'll get exemption, we'll end up scoring exemption. That's how we have to plan for each and every subject when there is a part one and part two. Even it goes similar with the ECIPL. And there is also one more subject where one part is 20 marks and the other part is for 35 marks. So where we have to concentrate on the less chapters but high weightage of the marks. So accordingly, we have to bifurcate and learn again and again, revise again and again. That is how we have to bifurcate. So coming to the first chapter, see here, the first chapter is Introduction to Company Law. Company Law. Just a minute. So many contents. See, that's how we have to study. We have to know each and every concept and every chapter. See, this is the first chapter. Whenever we are reading a first chapter, we have to be really get to know what are the concepts. See, we will be knowing what is company law, what are the agencies of the MCA and MCA services, and what are the prerequisites for the e-filing, which means what are the mandatory things we have to be having in our system to file the form to, ROC or CG. This is the outline. So straight away moving to the jurisprudence of the company law. Generally, see there will be n number of complicated words and very high amount of glossary of the words. But still, we end up putting and memorizing and putting lot of memory on that. So you don't have to do that really. See, one thing I'm very clear about, whatever the material you refer, whatever the ancillary coaching institute material you refer, just make sure you understand the same way whatever it is mentioned in the ICSI material and the coaching center material. For understanding purpose, yes, you can use it. For interpretation, yes, you can use it. But still, as on when once you are done understanding, please do refer the chapter, ICSI study material for sure. Minimum 3 times revision is mandated, because you don't know how exam in the exam it is going to be. There might be a statement and a comment they used to ask you. Unless you know the vocabulary and the sentences of the particular sentence, you end up you end up leaving the question and come back to the, you leave exit from the examination hall. That really makes you to lose few number of marks, lose in aggregate, despite of making a very vast number of hours of preparation revision that will go wasted. So make sure you do really study the study material at least 2 to 3 times for sure. Otherwise, that is really going to get wasted all your time, energy, effort, and everything. Okay. Introduction. First, jurisprudence of the company law. First, what is meant by jurisprudence? Jurist in the sense law, prudence means knowledge. What is the knowledge we have on the law of the company law? So it's just an introduction. You can give a gist of it. There's nothing more really, very important. First, it's a joint stock company. How evolution has happened till 2013 from 1850. You can give a read, and the important committees. So I don't think so. Every committee is important to her. Mainly this Reja Irani committee and the company law committee, which does have a significance, you can just give it a read. And what if in the exam they ask you what are the important committees? And also, one more thing people used to ask me often, is that really required to study each and every chapter? It's yes, hardly yes. But still, when you do really strategically divide the chapters and accordingly you leave. Like I said earlier, part two, there are only six chapters, but you end up the weightage of the six chapters is 40 marks. So, whatever the chapters you do, please make sure that you are aware of each and every concept of that chapter. Again, you don't have to read each and every chapter. We are humans. We cannot really memorize each and every section, rule number, examples, and everything. But what if in case the examiner is asking from that chapter alone? At least you should be knowing what is what to write in your own words. Something related you must be knowing. It's not like totally out of the box and you cannot write that way and it does not work that way. It never is going to work that way. So at least you must be having a knowledge of each and every concept of the chapters, whatever you are referring to. Even this is a company law, it is really a very core subject and very core concepts it is going to cover. So what I end up saying is just make sure you know everything. Again, reading everything, it's a really task and no one can do so, but at least you must be having an idea what is what. What is something that has been asked from the, which the chapter which does you didn't even have a read about it. You have to plan strategically, you have to know some idea. Okay. I don't want to waste your time as well. See, again, once again, if you people have already know about the course and if you already know all about other chapters and whatever I'm saying, you can just keep into in 1.5x speed and you can just continue to and don't waste your time for knowing the basics and everything. So you can just speed up the video in order to save your time. And there will be the company law committee that is also important. Next, what is the concept paper on the company? I told you earlier, JJ Irani committee. What if they ask you write a few words about the JJ Irani committee report? See, again, you have to know at least some based on that. So there is a committee. Why they used to? There will be a committee. Before making a law or before making any amendment or if before making any law in the parliament, they used to set up a committee. So the committee actually takes the inputs and whatever the research knowledge and how it has to be drafted, how well the people are going to get impacted. So in order to know all these things, they will be appointing one committee. So in this case, this is the JJ Irani committee which they have been appointed. So this committee is actually headed by JJ Irani, who then the director of the Tata Sons, with the government who proposed the revisions from 1956. Why? What is the object they have actually, they have given is sense. So simplified compact law, address the changes, international scenario and all. Again, all these are repeated in this broad recommendations. Okay. See, what are the recommendations have been done by the expert committee? Private companies and the small companies, they have given a flexibilities and the freedom of the operations and the compliance at low cost. See, for the private companies, compliance cost is way higher than the small companies. Again, small company definition is different, private companies definition is different. We'll read more in deep in the coming sessions. Private company, generally the compliance is like there has to be a 4 board meetings in any financial year. For sure, there has to be a four board meetings with the 120 days gap with the earlier meeting. But whereas for the small companies, there has to be a 2 board meetings in each, in every 6 months, there has to be a board meeting with a 90 days gap. We'll move forward. We'll read more about in the coming sessions anyways. And what is companies with a higher public interest? They are subject to, stricter regime of the corporate governance, which means the companies which have higher public interest. For an example, you just take when there is a coal manufacturing company or a cement manufacturing company. These companies used to release a lot of pollutants to the environment, which is really creating a big environmental risk. So, which is really a concern for the public, not only a public to, even environment for the other international organizations and everything. So all these companies actually they do, they do have much and more regulations when comparatively for the other private companies, small companies with higher corporate governance. Government companies and the public financial institutions should be subject to the similar parameters. See, whatever the government companies and the public financial institutions, they should also subject to the parameters with respect to disclosures and the corporate governance and as the other companies. See, it's not like government company will be exempted from the compliance and the disclosures. Comparatively, these companies will be having more compliance, from the private companies and the small companies. Even those companies have to comply with the compliance. That is one more recommendation. And simplified regulatory regime by the strengthened disclosure. So earlier it used to be MCA V2 version. In V2 version, we used to download the form, give the input data, and do scrutiny, and then we'll file. But in the V3 version, which is MCA V3, in the V3 version, you just have to log in. It's a web form actually. But with the login, only you can enter the data, and then and there you can upload it. And then you should have to download to affix the DSC, and then you have to upload. See, it's a quite a very big differentiation it happens. So that is why it is a simplified version. Next, and again to attain the Indian company law with the global reforms in the place of arena, which means, uh, you know, Indian company law has to be in line with the many other countries' law as well. For the UK, there is a separate law. For USA, there is Sarbanes and Oxalis 2002 Act. Accordingly, that is also in line with the Indian company law. So that is the one more recommendation which is given by the expert committee. So this is the recommendations. And there is a Companies Act when they have received the assent of the president. So the Companies Act, which is, so you don't have to remember the date and everything, but at least you should be knowing which month, and what is the year. And also one more thing, see, when the bill wants to get as an act, first they have to implement in the parliament for the both houses, Lok Sabha and Rajya Sabha. After getting approved from Lok Sabha and Rajya Sabha, that bill will be sent to the president for his assent. Again, for president in the sense I said his, it does not mean that that is excluding for the feminine thing. Masculine, it includes both his. All these things we used to learn in the jurisprudence chapter, interpretation of the statutes, where you will get to know if feminine, it does not mean that that is going to exclude masculine. It does include her also. So what I mentioned to say is, the Companies Act received the assent of the president. So you can just remember the date. You don't have to be really memorizing. So in the official gazette. And attributes. The Companies Act stipulates the enhanced self-regulations coupled with the corporate democracy. So the Companies Act, which has the following characteristics. Attributes in the sense it has a characteristics. Business friendly corporate regulations, pro business initiatives. So it has business friendly, which means people from, in nowadays in MCA V3 version, if the person doesn't have any DIN, also even if he doesn't have DIN, he can still incorporate a company by including all his details for the first three directors. So it's a very business friendly and a use of being website as well. And protection for the minority shareholders and investor protection and activism. Obviously, people who are holding really less than 10% share in a company, they'll be getting protected in the latest Companies Act. There is a stricter enforcement on the audit accountability. So auditors has to be very accountable and very transparent. There is an independent qualifications which they have to follow. So according to section 139, enhanced accountability of the management, how management has to be there. I mean, what are their duties and what are the board of directors' duties? Enhanced disclosure norms, which means for every now and then for the listed companies. See, I really wanted to mention something here. Enhanced disclosure norms in the sense, maybe we are reading as per the Companies Act, but in the SEBI regulations and all, it's more stringent than the Companies Act. You know why? Once the board meeting is completed, within 30 minutes, the compliance officer has to give what are the proceedings to the stock exchanges. If not, he'll get penalized within 30 minutes. That's how stringent be. You just imagine it what level of his reputation will be at stake if something is not really acting as per SEBI. SEBI is very stringent. People used to say whatever things you can do in India, but never ever mess up with the competition, CCI and SEBI and RBI. These three are really plays a pivotal role in the country. Okay, next CSR, better framework for the insolvency regulations, corporate social responsibility. Again, what is corporate social responsibility? See, why do you think Reliance and all this, whenever you go somewhere, you get to know this is donated by this SBI or HDFC or the table or the bench or the blackboard or the school? Why do you think they are donating? What, out of sympathy? No, that is not the way at all. See, whenever the company crosses the certain profit 5 crores, they have to mandatorily contribute something to society. That is what CSR. So when there is a profit turnover, net worth, when there is a certain percentage have been touched, I mean, when they have crossed that amount, when they have got a profit, they have to in return contribute to the society. That is the reason why people used to donate to the society. The law mandated them to do all these donations, not out of sympathy. Next, good corporate governance. What is good corporate governance in the sense, once everyone is following law, once everyone is in line with the employee laws, labor laws, obviously there will be the enhancement of the society. When the society is doing well, obviously GDP will increases. When GDP is increasing, the country is going to be in the number one category. So everything is interconnected. So the companies has to be following a good law compliance with that. Everything is connected, as I said earlier. So this is what attributes. The Companies Act introduced a new concepts, again, disclosures, accountability. Again, this is, you can give a gist of it. And reforms, that's what ease of doing business. What is the reason they have got the Companies Act 2013? What are the changes they have made in the 2013 Act? Next, this is very important. Doctrine of ultra-virus, not coronavirus. See, doctrine of ultra-virus, see in the examinations, what if they explain the doctrine of ultra-virus? Please make sure you write VIRES, not VIRUS. I know there is a very vulnerable chances to make the mistake of the ultra-virus and, but still. The doctrine is something called as it's a rule actually. Ultravirus, see, they have when ultravirus is a Latin term to words which means beyond virus. See, ultra, which means beyond, virus means the power or the authority. So, for an example, let us take an example. So you're going out for to meet some friend's birthday party or something. Your parents have given some deadline. You have to be at home by 8 o'clock. So till 8 o'clock, you can do whatever you so. When it time exceeded 8 o'clock, you cannot be at home. There will be the lot of scoldings and lot of punishment, and but still it happens anyways. So even in this law also there is an ultra virus concept, which means people who are from the commerce background, they'll be getting to know what is MOA and AOA. See, MOA is something called Memorandum of Association, and AOA is called Articles of Association. Memorandum is very particular, where it contains only 5 clauses. Name of the company, registered office of the company, objective class, what is the liability, capital clause, and everything. Only 5. So it's where if the company, see here it is there. See, that is what MOA. Ultra virus of the AOA. Generally, what is meant by AOA in the sense, how the company needs to appoint a number of directors, how the company needs to appoint on auditors, how the share transfer has to be happening, how it generally explains about what to do, what is the policies has to really enhanced by the company in order to have a good corporate governance. It's the internal management policies and everything that has to be included in the AOA. See, there is three ultra viruses which you shouldn't be exceeding at any cost. Ultra virus of the Companies Act, which means at any cost you cannot exceed the Companies Act. That means you cannot do which is not in line with the Companies Act. That will be a offense. And ultra virus of the Memorandum of Association, whatever it is mentioned in the MOA, you cannot exceed that. For an example, your object clause in the MOA is to manufacturing cement, but you cannot manufacture coal. That is ultra virus. You cannot go beyond that. And ultra virus of the Articles of Association, obviously, when you really have to appoint as a director, you can actually appoint number of directors, as a shareholder, maybe three directors. But what if you appoint more than three directors? That is beyond it. You cannot do so. You can do so, but there is an exception. We'll get back to that in the coming pages. First, what is ultra virus of the Companies? I guess you're getting my point. Please let me know in the comment section or something if there is anything you couldn't understand in deep. Please send me the mail. Accordingly, we'll have a detail. I'll be do whatever I can do for my best to your understanding and everything. Ultra virus of the Companies Act. So that's what. See, section expressly provides shall provide notwithstanding. That's what they were meant to say is whatever contained in the Companies Act, they should not exceed it. Such act is void and cannot be ratified even by the unanimous resolution of the shareholders. See, be very careful about this unanimous resolution spelling because people, uh, there might, because I did do small mistakes while writing exams, so I just don't wanted anyone to do the same mistake which I have done. So make sure this spelling is very, just do 2 to 3 times. Yes, everything is has to be in line with the study material. Okay. See, generally in law, to conduct a board meeting, at least 7 days notice has to be required. You cannot say that I'm gonna give 9 days notice. No, it is not possible. That is more than it is ultra virus of the Companies Act. If something is mentioned in the Companies Act 7 days, how can you really do do meeting by more than 7 days notice? You cannot do so. That is ultra virus act of the Companies Act. And for your example, that's what if there is any act which is excess or a contrary of the scope of the activities of the Companies Act, that will be ultra virus. So any act that shouldn't be contrary or shouldn't be excess in the scope of the activity of the Companies Act, that is void at any cost. You cannot even ratify. Ratify in the sense you cannot even rectify the mistake by the unanimous resolution of all the shareholders, which means you cannot even rectify or you cannot even sit all together by from all the shareholders. Okay, we really wanted to rectify the mistake. No, you cannot do so for this ultra virus of the Companies Act. So, example, if the board members are appointed or removed without the statutory provisions, these are the examples: payment of the dividend, reduction. There is a certain procedure for all these things. Share reduction of the share capital, dividend, Companies Act, legal formalities. That is ultra virus of the Companies Act. Next, ultra virus of the Memorandum of Association. You know what is memorandum? Here they have given the definition. Listing out the constitution of the company, essentially foundation stone. What is the structure it has? It contains the boundaries of the activities and relations in its outside world. If you see MOA of any companies, you will get to know what are all the objects of the company: name, registered office, capital clause. Once this video is uploaded, I'll try to download the MOA and whatever the MOA and AOA I do have for your reference. I'll just we'll see how things work in MOA and AOA so that you'll be getting an idea how practically it has to be happening. Next. So, ultra virus of the MOA. So, MOA, the Memorandum of Association of the company, which restricts the powers of the company while defining the objects of the company, cannot do anything which is beyond the purview of the objective clause. That's what I meant to say. So any act or the contrary to the objective clause of the clause of the memorandum of association will be ultra virus of the memorandum of association. That's what if the cement industry company has objects of doing cement manufacturing, it cannot do so for the coal manufacturing. That is totally ultra virus of the MOA. At any cost, even they cannot ratify as well, even by unanimous resolution. See, such act is void and cannot be ratified even by unanimous resolution of the shareholders. Next, ultra-virus of the Articles of Association. What is Articles of Association? Here they have given, see, bylaws and regulations of the management of the internal affairs of the company. Internally, how company has to run, how the company will delegate the powers to their shareholder, to management, and governing the company affairs and the rights and the members. If the company acts which are ultra virus of the Articles of Association, but intra virus of the Memorandum of Association, which means it exceeded the AOA. It exceeded, it is actually the act, whatever it is done, it is actually not even there in AOA, but it has done that act, but it is within the MOA. So in those cases, they can actually ratify by altering the articles by the special resolution. Special resolution again, ordinary resolution. There is something more you have to learn about that. Ordinary resolution is something. See, for an example, there is 100% of the share capital. 50% is held by one X person, 50% is by Y percentage. No, let me just take this example that will be the equal share. 51% I was holding, and the balance percentage is holding by Y person. So when the item has been placed, when the agenda is placed in the board meeting, just to pass that, 51% is required. That is ordinary resolution. So if I say yes to the resolution, yes, I wanted, for an example, I wanted to appoint one more director into the company. So yes, I wanted to appoint. If I say yes, that is of ordinary resolution. That can really well within, so the director gets appointed. But whereas when there is a special resolution concept, even if I'm holding 75 percentage, if the other person is holding 25 percentage, if the other person have told 25 percentage, it doesn't work out that way. Which means, this is again a very important concept. We'll be getting to know really in deep with the same examples and the practicals thing in the coming sessions. What is special resolution, ordinary resolutions? Let us limit to this thing. Ordinary resolution, it has to be more than 50 percentage. Special resolution, it has to be more than 75 percentage. As of now, you just keep that in mind. In coming sessions, we will be taking more examples for that ordinary and the special resolution. So all these are the case laws which we have to go further and deep. And we'll see in the next class. I just wanted to end this session. So I really wanted to know your feedback so that accordingly I'll make, if there is anything changes I wanted to do from my end, or is there anything you wanted me to do, enhance. In the next class, I'll just download the MOA and AOA maybe for your reference. With this, I'm going to end this session. Okay, so thank you so much. I don't know how many of you watching this video till this end, and do let me know if there is anything really you need to understand till today's topic. You can do mail me, and accordingly I'll reach you there, and I'll try to do my best. Okay. Okay then. Thank you. Welcome.